Welcome to this lecture on Foundations of Land Administration, Evolution and Institutions. In this lecture, I will talk about basic concept of land administration, its importance in economic development, the history of the land administration system in India, and the role of various institutions involved in land administration. First, let us understand the basic concept of the land administration. Land administration is a process of determining, recording, and publishing information about people's rights to land. It includes cadastral surveys, documentation of land rights, registration of land transactions, and resolution of disputes. Land is a crucial factor for all economic activities in a country, such as agriculture, industrialization, urbanization, housing, and infrastructure development. It also plays a key role in strategies for poverty alleviation, food security, and social justice. Therefore, a good land administration system is essential for economic growth and providing social justice to the weaker sections of the society. Historically, land administration has been a vital function for rulers because most of their revenue came from taxes on agricultural land. The collection of land revenue was the main incentive for rulers to establish land administration systems. Control over land was also a crucial source of political power. For example, the real political power of East India Company began when it got rights to collect land revenue in Bengal, Bihar, and Odisha. These rights were granted by the Mughal Emperor Shah Alam II after his defeat, Battle of Buxar in 1765. This power to collect land revenue led to the gradual increase of financial resources and political power of the East India Company, which ultimately resulted in British rule over whole of India. With this background, let me talk about the land administration systems in India. Recording of land rights is a very important component of land administration. In India, there are two subsystems to keep records of ownership and other rights in land. That is, the record of rights and registration of deeds. First, let me talk about the record of rights. The record of rights was introduced by the British in 1822 in the United Provinces. After that, it was adopted in all the provinces under the British rule. This record is maintained by the state revenue departments under the provisions of state-specific land revenue laws. These laws follow a similar pattern throughout the country with minor variation from state to state. Unfortunately, in the past 200 years, hardly any change has been made in land revenue laws. The revenue department has a hierarchy of officials such as Patwari or Talati, Kanungo, Tehsildar or Talukdar or Mozadar, Subdivisional Officer, Collector, Commissioner, etc. They perform various functions relating to land administration as per the provisions of relevant laws. The record of right has two parts, a cadastral map and a set of registers documenting land rights and other details of land. Cadastral maps prepared by the Revenue Department are different from topographical maps of Survey of India. A topographical map shows only point locations of geographical features, but a cadastral map shows the boundaries of each plot of land in a village. With the help of cadastral maps, the boundaries of a plot can be demarcated on the ground. Every parcel of land is given a unique identity number and rights are recorded in the registers with reference to this unique identity number. The register that documents ownership and other land rights is known by different names across various states such as Jamabandi in Punjab, Arangal in Andhra Pradesh, Khatia in West Bengal, and Khatoni in Uttar Pradesh. Thus, rights over a particular land parcel can easily be identified through the record of rights. Further, the boundaries of land parcel can be demarcated on the ground with the help of cadastral maps. This record is regularly updated through procedure laid down in the law. Whenever there is a change in rights due to sale, gift, or inheritance, a designated official holds a quasi-judicial inquiry and records the name of new right holders. This process is called mutation. The record of right is a crucial document for determining ownership and other rights to a parcel of land. Legally, the entries in the record of rights are presumed to be true until proved wrong. Therefore, for all practical purposes, the record of rights is considered a good evidence of ownership and other rights in the land. However, an aggrieved person can challenge any entry in the record of rights before designated authorities of the Revenue Department or a civil court. The record of rights is corrected as per the decision of such authorities or the court. Main purpose of introducing the record of rights was to maximize the collection of land revenue, which formed 60% of the total revenue of the British government. But now, record of right is not maintained for this purpose because land revenue makes a very insignificant contribution to the state exchequer. Now, record of right is maintained as a service to the people. It helps landowners in sale and purchase of land, demarcating boundaries of their lands, resolving land disputes, and obtaining bank loans. The record of rights provides very useful data for implementing many government programs also, such as granting ownership rights to tenants on agricultural land, distributing land to landless, estimating agricultural production, providing subsidies on agricultural inputs to farmers, crop insurance, housing grants to the houseless people, etc. Now let us talk about the deed registration record, which is maintained by the registrars under the provisions of Registration Act 1908. Under this act, deeds relating to transactions in immovable property, such as sales, gifts, mortgages, and long-term leases, are registered in the office of a registrar or sub-registrar. The registration of deeds was first introduced in Bengal Presidency in 1793 by the British. Shortly thereafter, registration was introduced in Madras Presidency and Bombay Presidency also. The objectives of introducing registration were to provide security of title to the person acquiring property, prevent fraud in property transactions, and preserve authentic copies of deeds to avoid future litigation. At that time, registration of deed was not compulsory, but a strong legal rule gave priority to registered deeds. The registration of a deed invalidated any other unregistered deed in respect of the same property, whether executed before or after the registered deed. Thus, registering a deed protected a person against fraudulent unregistered transactions concerning the same property. A significant change in the law on the registration of deeds came with the Indian Registration Act 1866. This act made the registration of certain transactions like sales, gifts, and mortgages compulsory. Such transactions were legally invalid if not registered. This act was replaced by the Indian Registration Act 1871, which was again replaced by the Indian Registration Act 1877. Finally, the Registration Act of 1908 was enacted, which is currently in force. It is compulsory to register most property transactions such as sales, gifts, long-term leases, and mortgages under the Registration Act. Certain transactions such as transfers through inheritance, family settlements, leases of property up to 1 year, transfer of property through a court decree, and grants of land by the government are exempt from registration. State governments appoint registrars and sub-registrars in each district to register deeds as per provisions of the Registration Act. Generally, the collector of a district is appointed as registrar, and a sufficient number of sub-registrars are appointed who work under the supervision of the registrar. To register a transaction, the parties sign a deed which contains all the details of the property and terms of transfer of that property. Then, the parties appear before a sub-registrar and present the deed for registration. The sub-registrar examines the deed to ensure that it is presented within a prescribed limit and contains all details as per the Registration Act. Then he verifies the identity of the parties and also inquires whether the deed has actually been signed by them. Once satisfied, he records a registration certificate on the deed and retains a copy in his office for future references. Having explained the registration process, let me now discuss the legal significance of registration. First, registering a deed has the effect of giving notice to everyone interested in that property. This is so because record of registration is open to the public. Anyone can see this record and obtain copies following the prescribed procedure. Secondly, if a compulsorily registrable document is not registered, it is considered invalid. An unregistered deed for such a transaction is not accepted in a court of law as evidence. Thirdly, registration of a deed serves as evidence that a transaction has taken place concerning the property as mentioned in the deed. However, the registration of a deed has certain limitations also. While it is a good evidence of the transaction, it is not conclusive proof that the title of properties has actually been transferred to the transferee. For example, A sells a plot to C through a registered sale deed, but he hides the fact that half of the land belonged to his brother B. In this case, the purchaser C will not become the owner of full plot just by registration of the sale deed. Regardless of what is written in the sale deed, B will become the owner of only half of the land that was under A's ownership. Such a situation arises because, as per the Registration Act, a registrar is not required to investigate the title of the seller. It is the responsibility of the purchaser to inspect all relevant records of the property to ensure that the seller has a good title. Another limitation is that in most cases, a cadastral map of property is not attached to the deed. Therefore, the boundaries of the property cannot be demarcated using the registered deed alone. As mentioned before, many transactions such as inheritance and family settlements do not require registration. Therefore, such transactions do not appear in the record of the registrar. Consequently, the record of the registrar does not provide a complete picture of the land ownership. In contrast, the record of rights gives a more comprehensive view of the land ownership and other rights. After discussing the record of rights and deed registration, I would like to touch on the role of civil courts in land administration. As discussed earlier, ownership and other land rights are recorded in the record of rights after an inquiry by the revenue officer. Therefore, an entry in the record of rights is presumed true unless proven otherwise. However, the final adjudication of land rights can be done only by a civil court. For instance, A sells land to C, hiding ownership of his brother B on half of the plot, and C gets his name recorded in the record of rights as the owner of the full plot. In such a situation, the other brother B would have to go to the civil court to claim his ownership of half of the plot. The revenue officer will correct the record of rights based on the order of the civil court. Thus, in case of a dispute, the final adjudication of land rights comes within the purview of the civil courts. Before concluding, let me summarize the main points of my lecture. I told you that land administration includes cadastral surveys, documentation of land rights, registration of land transactions, and resolution of disputes. Then we discussed two subsystems of maintaining land records in India, that is, record of rights and deed registration. The record of rights has cadastral maps and gives a more comprehensive picture of rights of people over the land. Entries in the record of rights are presumed to be true until proved wrong. Deed registration creates evidence of transaction but is not conclusive proof of transfer of title. In cases of dispute over rights in land, civil courts have the final authority to adjudicate. Records are corrected as per the decision of the civil court. Now I conclude, and I hope that you find this lecture useful. Thanks.